Well, what's interesting about this is it really opens the door to not guilty by reason of insanity. And in California, you guys, it's a really high bar to get not guilty by reasons of insanity. We use something called the McNaughton rule. And this law, this rule is very specific. And what it states is, did the defendant at the time of the act not understand the quality of their act? And the second part, if they did understand, they didn't realize it was legally wrong what they were doing. The McNaughton rule, it doesn't erase intent. So if the person had intent to kill, guess what? McNaughton does not apply. It also does not, it doesn't cover whether the person can't control their actions. So what that means is if the defendant can't control what they're doing, that also doesn't qualify under McNaughton. It is a very high bar. And what happens is, in front of a jury, the defense attorney will argue whether, the case is proven beyond a reasonable doubt or not. If the jury comes back and finds the defendant guilty, the jury goes back and decides whether the defendant was not guilty because of insanity or whether that defense does not qualify. Again, it's a really high bar. We've had a lot of parent side cases in California, and honestly, it's a very rare case where not guilty by reasons of insanity is actually latched on by juries. And by the way, the parties, they usually don't stipulate to this defense, especially I think with this high profile case, the Los Angeles District Attorney's Office, they really do want life without the possibility of parole. So we'll see how the defense handles the insanity defense, and we'll see also how they handle, again, Nick Reiner's very long history of addiction and what we found out, mental illness.